Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press. It's a book which I found fascinating. It's called Wrongs and Crimes by Victor Tadros. More about him in a moment. OUP have produced a really interesting book here, I think. And this is the quote that I've given it. "I hate this book," so says the author. A great discussion point for an examination of the relationship between wrongdoing and criminalisation. Now, all will be revealed in a minute about why he said that. Here's the front of the book. It's a hardback. There we go, that's the spine, and then there's the back. The Criminalization Series is listed. It's got a dust cover on it. The inside dust cover lists again the series on criminalisation, and this just gives you some basic blurb about the book, some of which I've used because there are some quite useful quotes in it. The subject index is very short. It's on page numbering, and then there's an index of names which is split. That's quite useful, especially in these types of work, rather than just having everything together in the one index. Then you've got a very detailed bibliography which is done on an alphabetic basis. The front of the book runs to something like 350 pages. There's the actual front cover there, the front first page. Information about Oxford University Press, and then there are the acknowledgements. There's a lot of research has been done on this subject. You can see there's footnoting, which is plenty. Then you've got the table of contents, splitting it up into the various parts. There are 4 parts: punishing wrongs, criminalisation in principle, wrongs, harms and consent, further reaches of the criminal law, in 17 chapters. Then you've got an introduction, nice little quotes at the front. Then of course you've got from that a whole range of different subheads. You've got subheading, sometimes numbered, and you've got the actual footnoting. So there's quite a lot of footnoting. Tadros does like to use a little bit. He doesn't go over the top, you'll be pleased to hear, but there is a lot of detail in this. For instance, Chapter 9, the core case of criminalisation, very important, probably gets to the heart of the issue to a certain extent there. Because what is a wrong and a crime? Of course, there's a very good argument as to whether a wrong should be a crime, because we do, for instance, just to throw a spanner in the work, have the concept of the law of tort, which is French, of course, for civil, for wrong, tort being a civil wrong, whereas a crime being basically an offence, which is a wrong against the state, as opposed to the wrong against an individual, although it overlaps. So you can see how complex it gets very, very quickly. Anyway, why does he hate this book? That's the big question. It's another, well, I'll give you the answer to that. It's another most important title from, sorting that out, from OUP, and it's just been published in their Criminalization Series. And this book has been written by Professor Victor Tadros. Now, he's well known to many people because, in fact, some of the books that he's produced are in the Criminalization Series, which are listed on the back. So he will not be a stranger to many readers. Anyway, at least he's candid right at the start by saying, "I hate this book." Although we have to add, he says, "I have failed to write it for a long time, and not for want of trying, but here it is now," of course, and he has done it. I don't think he hates it quite as much as he may protesteth a bit too much on that. We shall see. The book, though, can be assessed on a number of different levels within the criminological community. For both scholars and academics, we found the commentary on the scope of criminal law to be far more readable than the author admits, because practitioners are realists. We have to be, after all. So we recognise that no one book can consider all the issues which are relevant to the scope of our criminal law. But it is a start, and a most welcome start for the academic lawyer in our view. The book's synopsis describes OUP's Criminalization Series as emerging from an interdisciplinary investigation into criminalisation, focusing on the principles that might guide decisions about what kinds of conduct should be criminalised and the forms that criminalisation should take. So that's the basic mission. the author has developed what he calls a normative theory of criminalisation, so that OUP in their series review the key questions at the heart of the issue, which are set out in the following way. And this is really the list which he's got, and I'm going to review here the list that he's set out as his sort of terms of reference. What principles and goals should guide legislators in deciding what to criminalise? Very good question. Trouble is, it is based on the time and period you're in, I think, to a certain extent. How should criminal wrongs be classified and differentiated? Again, we've had different structures between the less serious, the more serious, and so on. And finally, how should law enforcement officials apply the law's specifications of offences? Well, that's really where the politics ends and the handing over to law enforcement agencies begins. But of course, the bottom line on all of that is that the politicians are eventually the people who take the can. So therefore, although they don't get involved in the actual operational work, you can see that there is bound to be a knock-on effect even in 2017. Now, Wrongs and Crimes is the 6th volume to appear, giving criminologists a philosophical investigation of the relationship between moral wrongdoing and criminalisation, which we consider a most important title for the law undergraduates reading list. And certainly I think if you are reading criminology, and to a lesser extent probably jurisprudence and philosophy, this book is a must. The contents of Tadros's book cover a consideration of the justification of punishment, always interesting this one, the nature of harm, the importance of autonomy, inchoate wrongdoing, the role of consent and the role of the state. And what we found particularly helpful was the detail concerning the nature of moral wrongdoing, the sources of wrongdoing, why wrongdoing is the central target of the criminal law, and the ways in which criminalisation of non-wrongful conduct might be permissible. And that, of course, is the way in which the arguments are developed by the author. Tadros succeeds admirably, we think, with his mission to consider the nature and sources of wrongdoing, which every law student must begin with, both with personal and interpersonal responses, which of course then arise. He goes on to evaluate the response that the state should make, which is so often understated and ignored when it comes to how to deal with such wrongdoing. And it's a great tribute to the author that he's been able to sift through the vast literature this subject generates to give us, as the readers, a coherent 17 chapters in such a lucid way, thus making the book both readable and lovable, to use my expressions, to us at any event, and no doubt to a new generation of applied criminologists, and possibly budding jurisprudents. Well, thank you very much, Professor Tadros. The publication date is cited as at the 15th of December. So a quick look again at the book. There's the front, spine, and then the back. It's as I say, it's a hardback, but it's quite light. It doesn't run 350 pages, something like that. Just opening it in the middle. What preventive aims? That's an interesting question. Again, you can see the structure. You have the footnoting at the bottom. You do have a little bit of subheading. There's quite a lot of quoting, and I think quite a lot of very useful points that come out. This is again the core case of criminalisation, which I referred to earlier on, because that gets to the heart, I think, to a certain extent, of the issues. Public wrong, he calls it public wrongness. In fact, that's, again, as I've said before, I think a lot of what you have to do in this day and age has to be set in the social context of the time, because what is a wrong and a crime, or what is a wrong but not a crime, could very much depend. I mean, the classic example, for instance, is the law about homosexuality and the fact that it was considered a criminal offence at one stage, and now we've got a complete change round with a whole range of things happening to decriminalise it and to at the same time look again at the people who were the subject of convictions in the past. So you can see the whole way in which the subject matter itself is looked at again. So that just is one minor comment I would make. But thank you very much to all concerned for another excellent book from OUP and a great criminalisation series. Thank you. Bye-bye.